Good afternoon, everybody. Welcome to the House Standing Committee on Judiciary. We have a very full agenda today, and I'll direct some of those comments in just a moment. But for now, Madam Secretary, please call the roll.
Representative Blanton.
Present.
Representative Bratcher.
Here in the room.
Representative Cantrell. Here. Representative Decker.
Present.
Representative Elliott.
I'm present in the room.
Representative Fisher.
Here in the room.
Representative Hebron. Representative Kulkarni.
Room.
Representative Lewis.
Present in the room.
Representative Maddox.
Present for my annex office.
Thank you. Representative McCoy.
Here.
Representative Minter.
Here.
Representative Mosier. Representative Nemes. Here. Representative Petrie. Representative Scott.
Present.
Representative Stevenson. Representative Manta.
Here in the room.
Chairman Massey.
Here in the room. All right, so let me explain a few things for purposes of today. We have 5 bills and we have an hour and 45 minutes. That means the total presentation of each bill is going to be around 20 minutes. We have some people speaking in opposition on some bills, so I want to remind the sponsors and remind all of those who are testifying that we need you to be to the point quickly. We don't have time to meander much today. Also, given some events earlier in the session, we will always conduct this meeting with civility. If we have anything that's otherwise, then we will address it appropriately. No signs are to be permitted in the room. If you have a cell phone, please turn it to off or to vibrate or some other mechanism so it doesn't disturb the meeting. And note that the microphones are very sensitive. Finally, if you are a sponsor or you are a presenter, please make sure that your microphone is on at the testifying table. And we will remind you if not, but try to make sure the microphone is on and that the microphone is called or pulled close to you so that everyone can hear. Today, if Representative Mosier is ready, not trying to put you on the spot, Representative, but I did tell you that I'd call you first. So we have House Bill 362, which is sponsored by Representative Mosier. And when she gets situated, and I think she has somebody with her today that's going to possibly testify, I'll have her introduce herself and her witnesses and proceed.
Do you want to switch places on the agenda or do you want to keep going with that?
Mr. Chair, one of our guests is running behind. Would it be okay to switch places? I'm so sorry.
No, that would be fine, Chair. We will switch over if if Representative Bratcher is ready. We are ready to proceed with House Bill 318. He told me he stays ready, so you don't have to get ready.
Let me say that I'm working with Louisville today, Mr. Chair. In 19 and 2021, we talked about the dire need for state involvement in what had gone on in Louisville and gave an overview of what had happened in Louisville to that juncture. Quickly, I will explain how 2021 wrapped up. We had 188 homicides. That's the most homicides we've ever had in the city's history. That was on top of 2020, where we had 173. That was previously the all-time high. 641 Louisvillians were non-fatally shot. Of those, 24 of those murder victims were juveniles. 123 juveniles were shot in the city of Louisville. The city of Louisville in 2021 averaged more than a carjacking every 2 days. If you extend out this time period through the first 6
In Henderson, we've had several cases where truancy, the kids that have already been habitually truant, have been through a truancy diversion program, have missed over 100 days of school, and the case still hasn't come to court. Well, that's a problem. That kid's school year is shot. It's gone. That's not accountability. That's not real intervention. That case needs to come to court for some sort of judicial intervention. Also, we see juveniles who are not able to participate in diversions merely because their parents are not cooperating. And there's nothing really that a court can do about that right now. House Bill 318 addresses that. It allows judges to see the case come to court, but send it back to diversion with orders to the parents to be involved in that and to cooperate with that diversion, to allow that youth the opportunity to have those interventions. In the middle of the spectrum, it tolls the time period for probation if there's a violation. Currently, if there's a probation violation, there are set time limits on how long that probation can be. What happens is the case gets into court, and then there's a lot of maneuvering to where people run out the clock. They play four corners offense. And then as soon as that time period goes where there's not going to be real consequences, then they go ahead and handle the case. That's not effective. That creates an atmosphere of no accountability for these young people. And for the most violent of felonies, it requires detention in a secure facility until the detention hearing can be held. And it allows public access to records of those proceedings in the most violent of felonies only. And this is something that, like these gentlemen said, it's a big issue in Louisville, but frankly, this is an issue all over the state. We are seeing an increase in young people with guns. And that's something that we've got to have meaningful early interventions to address. And House Bill 318 is a step in that direction. Thank you.
You know, Mr. Chairman, some of the members might not remember Senate Bill 200. What it did was expand and come up with diversions and alternatives to when juveniles get in trouble. And you can consider this to be maybe a course change for that bill. It was like 7 years ago, maybe 5?
2014.
2014. And, but almost immediately, within 1 or 2 years, the police in Louisville were saying that there's some loopholes that need to be changed. So I'm glad we're getting around to doing it. Hopefully this will pass. And the intentions of Senate Bill 200 were grand, but there were some loopholes, as has been stated, and this would close many of those up. So I sure hope. Is it appropriate if I make a motion to?
I make a motion.
Representative is going to make the motion on your behalf. Do we have a
Okay.
second? We have a second by Representative McCoy. I will say, as I'm looking for questions, thank you for bringing the bill, and I appreciate the flexibility within the bill to allow the officials that are dealing with it to make the necessary changes that may inevitably arise. I saw a hand over here. Representative Scott.
Thank you, Chairman. Chairman Bratcher, just have a couple of questions for you. So I'm looking at Section 1 of the bill, and it talks about the court may order parental cooperation and refer the case back to the court designated worker. Can you just explain a little bit about what parental cooperation would look like, possibly?
And I'll defer to the experts on that.
I'll talk a little bit about that. We've had a lot of young people who have been entitled to a diversion, but they can't drive, they can't get themselves to appointments. A lot of times these referrals for diversions will include things like some sort of counseling, some sort of mental health assessment, things like that. And over, parents are refusing to get the youth to those appointments. And so that ends up going to court as a failed diversion through no fault of that young person's, through no fault of theirs. And so what this allows is the CDW, rather than just referring it to court, they can refer it to court essentially with a tag on it that says lack of parental cooperation. And at that point, the judge can look at it and determine whether it would be appropriate to enter orders ordering the parent to go to this appointment or something like that.
That's helpful. Thank you. If I may ask another. Thank you so much. Mr. Talley, good to see you again. You talked about folks getting out on quick releases, which, is really interesting. Not everybody gets out quickly, especially girls and women. So that's an issue of concern for me. So I'm not sure who Chairman Bratcher would answer this question, but I'd like to know, in Section 2, it talks about shall be detained in a secure juvenile detention facility. And so I'm curious to know, what are those detention facilities here in Kentucky? Because I can't help but think about Janiah McMillan, who died in a juvenile detention facility. So what are those facilities, And then how are we making sure that these kids are safe in these facilities?
Well, I do know that, when the JY Center was shut down in Louisville, that many times they're taken to Oldham County, and you guys correct me if I'm wrong, but that has been a problem. Anybody else want to elaborate on that?
Within the Louisville metro area, there is a facility on LaGrange Road that has opened since the juvenile facility closed. There are also a number of facilities across the Commonwealth that would qualify for these juvenile detention facilities, but the primary one for Louisville metro at least would be that LaGrange Road facility. But across the Commonwealth, there are a variety of facilities.
Can I follow up, please?
Please, quickly.
So if Chairman Bratcher, and I usually don't take this much time on questions, Chairman, so I'm going to try to,
I understand.
I'm going to move quickly. Chairman Bratcher, if someone could get me that list of facilities, because I'm not only thinking about Jefferson County, I am thinking about the entire Commonwealth. So thank you so much.
Representative Decker.
Yes, thank you. Thank you, Mr. Chairman. I want to commend all of you for bringing this bill, working on this bill. I particularly appreciate you, Mr. Crawford, and the Pegasus Institute working on these matters, for former U.S. Attorney Coleman and all the excellent work you all are doing. I worked with Senator Rand Paul for 5 years in the west end of Louisville on various initiatives and made many lasting relationships of people like Pastor Jerry Stevenson, Christopher 2X, Sean Gardner of 201 Families, Fathers and Families. Do those people, do you know if Christopher 2X is on board with what you're doing in this bill?
I can't speak for
Okay.
anyone
right.
other than Chris, but they generally do not weigh in on legislative
I
matters
understand.
like this.
I understand. I think it's thoughtful. I've talked with you about the bill, and I appreciate the effort. Thank you very much.
Well, I do have another question. Representative Stevenson.
I have a couple of questions. And we talked about these yesterday. And from what I understand, this bill will take young children that are in 10 categories and considered dangerous and put them before a judge in order to put them in perhaps a detention facility. And right now they cannot be held, but this bill will allow them to be held for 48 hours.
So the detention provision in here allows for violators of KRS 532-200. I think I got that right. Yes. To be detained for a maximum of 48 hours to see a judge. It does not dictate anything about detention or lack of detention after that period. And so a judge could still release that person if they're not a public safety risk, if they're not a flight risk, anything like that. But that sort of until they see a judge, they could be detained for up to 48 hours. That is correct, yes.
Okay, excellent. Another question, Chairman. Are there wraparound services, like we talk about gun violence? Are we doing anything about that? At the LaGrange place where they're putting these children, are there services for mental health, food? What are we doing to interrupt whatever it causes them to be in that spot?
I'll take a stab at that. So one of the things we're doing at the Office of Safe and Healthy Neighborhoods, and part of that $15 million investment of ARP funding, is to provide just that type of resources, those types of resources to those kids. One of the programs is trauma-informed care. And so one thing I want everyone to understand is it's not just the victim, it's not just the perpetrator, it's their siblings, it's their neighbors, it's the kids at school that are impacted by this. And so getting out into the community and providing trauma-informed care for the entire community is important. Part of GVI is when we go out and what is called a call-in, and so we go out with LMPD, we go out with someone from the community, usually from the religious community, and then someone from our outreach, an offer of services. What do you need? What can we provide you to help make that change? Do you need anger management? Do you have issues with de-escalating events that are occurring in your life? Do you need substance abuse help? Do you need mental health support? All of those things are offered at that time. And so and even further than that, because I think we did that before, but part of what we're doing now with the additional funding is providing ongoing case management. So that kid says, no, I'm good, which most of them will say at that first offering. We stay in contact with them. We go back a week later. We go back. And usually at some point that kid breaks down, they gain a little trust. And then what I've been told by the outreach workers, at some point that kid breaks down, tears flow, and they go, yes, I need help. I want help. And so to answer your question directly, we are trying to provide that ongoing support and make sure they get the resources they need to make the changes to get away from that lifestyle.
And
just
just
as
one
a
more.
brief
Okay,
follow-up to that, Representative Stevenson, these are Department of Juvenile Justice facilities, and they do have mental health providers on staff that do those interventions and partner with other organizations to provide that case management, which is such an important piece.
How many kids would this impact, and what's the number of beds at the LaGrange facility?
So I am not sure the direct number of kids that this would impact. There are currently 16. There are currently 16 beds at the LaGrange Road facility. It is my understanding that there is a request from Metro government to expand that facility some.
So anybody held under this rule will have to go out to other places in Kentucky?
I don't know if the LaGrange facility is currently at capacity and if that changes from day to day, so it wouldn't necessarily be the case. But in addition to whatever that scenario is, I believe that there is an attempt to expand that facility as well.
Just one last question, and this is to the attorney. How much success have we had in ordering parents that don't care to care?
That is an age-old issue and an age-old problem, and I think it is something that does take a more holistic approach, a more trauma-informed approach, because what we find is there's so much going on besides whatever particular antisocial act that this young person has engaged in. That's usually the tip of the iceberg, and there's so many more interventions that have to be put in place, and part of that involves making sure that there are those interventions at the court-designated worker stage, which is a pre-court stage, and then also on the back end at the Department of Juvenile Justice stage. What House Bill 318 does is it tries to cut down a little bit of that middle area where, because there's kind of a lack of overlap between the CDW and the interventions that they can provide and the Department of Juvenile Justice. One's pre-court, one's post-court, and there's not a whole lot in the middle. And that, like I said, that case management piece is so important.
Thank you, Chairman.
Thank you very much. Seeing no further questions, and we have a motion and a second on the bill. Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Cantrell,
Yes.
Representative Decker,
Yes.
Representative Elliott,
Aye.
Representative Fisher,
Yes.
Representative Hebron,
Yes.
Representative Kulkarni.
Briefly explain, Chairman. I'm a pass for today. There have been some serious concerns about mandating detention for juveniles and their impact, and its impact on the juvenile development. So I'm going to pass. I want to get some more information from the sponsors and from some other stakeholders as well.
Representative Lewis,
Yes.
Representative Maddox.
Yes.
Thank you, Representative McCoy.
Yes.
Representative Minter.
Briefly explain my vote. Today I'm going to pass for the same reasons Representative Kulkarni stated. I'd like to talk with you all a little bit more about this, and some other stakeholders have reached out to me, so I just want to have a few more conversations. So pass for today. Thank you.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Scott,
Pass.
Representative Stevenson,
I explain my vote. I'm passing because there's something about what the government and the court systems can do to better address this situation that we're not doing. So I'll pass and have that conversation.
Chairman Massey.
Yes, there being 14 yes votes, 0 no votes, and 4 passes, the same will be reported with favorable expression that the same should pass. Thank you for an excellent presentation. And Representative Mosier, are you now ready? And Mr. Gold, as you leave, I missed your mohawk today, so I hope to see you in it soon.
See you in June.
All right, good deal. And while Representative Mosier is coming forward, I do have a guest I wanted to recognize. There's a Bryce Clayton with us here today. Bryce, if you raise your hand. He is a first-year law student at Chase College of Law. His father is the superintendent at Warren County Schools, and he's here today to see what we do in Judiciary. So welcome. And I do think everybody's on deck now, Representative. I think I was told that your other people were here. So
Yes.
when you're ready, you can identify yourself, identify your guest, and proceed.
Thank you so much for being here. Thank you, Mr. Chair. Thank you, committee, for the opportunity to come back and discuss this important piece of legislation, House Bill. Well, I should say I'm Representative Kim Mosier, representative of the 64th District, for the record, and I'll allow my guests to introduce themselves in just a minute. But House Bill 362 is a law that became, or a provision that became law in 2014, and what we are doing today is updating the burden of proof because there have been some constitutional challenges to this bill, and we just want to make sure that we get it right. The law was in response to the tragic death of Matthew Casey Wethington, who died of a heroin overdose at the age of 23, and Mrs. Wethington, Charlotte Wethington, is with us today. Since 2004, there have been more than 6,000 referrals in Kentucky into treatment due to Casey's Law. It's a very successful program, and we want to make it even better. So that's really why we are here today, to provide life-saving treatment to individuals with a substance use disorder who need it. And we believe in Casey's Law very much. We want even more victims of substance use disorders or with substance use disorders to be able to get the treatment that they need. And so that's what we're here to discuss today. Also with me, I have Mr. Blake Christopher with the Attorney General's office. So I think I will hand it off to Blake first. If you could introduce yourself and proceed, and then Mrs. Wethington.
Good afternoon. I'll try to move fairly quickly through the two what we think are minor changes to this bill, and then we'll push it to Ms. Wethington to introduce herself and give her unique perspective on this issue. So the two changes that you have before you today are one, that create a beyond a reasonable doubt standard that a petition must meet before someone is committed to treatment, and two, to allow someone up for commitment to cross-examine the health professionals who examined or submitted written testimony about him or her. Now, before we talk too much more about those changes, I want to reiterate something that Representative Mosier just said, and that is that everybody here is a fan of Casey's Law, and that we support what the law does, and we want to ensure that even more individuals have the opportunity to get the treatment and the help that they need. Part of the reason for these changes is that Casey's Law is currently not being enforced everywhere in the Commonwealth, and we want to try to fix that. And we want to make sure that you can get the help that you need irrespective of where you live. So let's talk about the first change, the beyond a reasonable doubt standard. Casey's Law currently provides for two hearings, if you will. In the first hearing, the judge examines the documents that are filed in the petition, filed in the record, and questions the petitioner, usually a family member, about the need for the son or daughter, brother or sister to receive treatment. And then in the second hearing typically is when the judge makes the determination about whether that individual should be committed for treatment. Currently, Casey's Law establishes a burden of proof for that first hearing, which is probable cause. It's a pretty low burden to meet. There are some who argue that the second, for the burden of proof for that second hearing is a little bit in doubt, and what burden the judge should use there, they argue, is sort of up for interpretation. Now, we don't necessarily think that argument is correct, but we support amending the law in order to clarify what we think is already clear to us. And so what we would do there is create a beyond reasonable doubt standard for the second hearing. We think this is fair given the civil liberties that are at stake, and we don't necessarily think that it will disincentivize or negatively impact the number of individuals who qualify for treatment. Part of the reason we believe this is because there are a number of judges across the Commonwealth who are already using a beyond a reasonable doubt standard in that second hearing. Now, the second change, Casey's law currently requires 2 healthcare professionals, one of whom must be a physician, to examine the individual in question and to submit their findings to the court. We believe that if the individual who's up for commitment wished to do so, that he or she could currently subpoena those professionals for cross-examination. There are some who disagree or who say that Casey's law is deficient because it doesn't state so specifically. So our second change would simply write into Casey's law what we already believe to be true, which is that an individual up for drug treatment may subpoena the healthcare professionals who examined him or her. With that, I'll just simply say that, again, we're big fans of what this does. I'm from Estill County in eastern Kentucky. At one point or another, Estill County led the state in the number of overdose deaths per capita. If my memory serves, at one point in time, it was close to almost 1 out of every 1,000 people in my hometown died annually from a drug overdose, and I'm tired of it. We've got to do more to help those folks, and I think one of the ways that we can do this is to shore up the good work that this law does. With that, I will pass it over to Ms. Wethington, and we're very grateful for her presence and for her support for this.
I'm most appreciative of being here today and having the opportunity to share with you about Casey's law and what it has meant to so many people in the state of Kentucky and their families. It's been almost 2 decades now. It will be 2 decades in August of this year that we lost Casey, and we were facing the worst nightmare of our lives. We were losing our son to a chronic, progressive, potentially fatal illness, and there was absolutely nothing that we could do to intervene on him. At one point, I did call the prosecuting attorney's office and ask them if I could, somehow use the court to get help for Casey. I knew he needed it. At the time, I was very ignorant about the disease of addiction. I really did not realize what we were dealing with, but I knew it was serious and that we were in danger of losing Casey. And actually, I talked to that prosecuting attorney on Saturday, and we were recalling that conversation that she said I could do that. I could have Casey arrested if I had something that I could charge him with. But then to know that there was nothing that I could do after that the court would be in charge. And I was afraid, and I backed off. And so every day now I live with, what if I had made a different decision then? What if I had said, let's get Casey arrested? Would it have made a difference in the trajectory of his life? I don't know. It's over now, and I can't do anything about helping Casey. But I know that at that time we were told that he had to want to, lose enough, and hit bottom. He did all of those things. And I know that the bottom line is this: you have to be alive to recover. That has been the intention of Casey's law from the very beginning, to help families, to give them an option, a tool that they did not have before, and to protect the respondent so that their rights were protected. That has always been of utmost importance. As we were drafting the language in 2004, actually, I was asked to clarify that. It was 2004 when Casey's law passed. We brought it to the legislature in 2003, and we're back in 2004 at the passage of the law. I know that Casey's law has helped to many Kentucky families to get their loved one into treatment so that they have a chance to recover from this disease. Most of the reports that we get are anecdotal reports, people saying, thanks for Casey's law, and There was one comment that I was going to share with you from Manchester, Kentucky. We here in Manchester, Kentucky value Casey's Law like we value bread. That may sound like a weird analogy, but just as bread gives life, so does Casey's Law. And then Jacob wrote to me, I just wanted to reach out to you and let you know that Casey's Law saved my life and gave my daughter a father. Thank you so much. I'm a strong believer in Casey's Law. That's just a sampling of what people have said about Casey's Law. I know that sometimes it's reported in the paper that Casey's Law is a little used law. Contrary to that, from 2004 to 2021, the total petitions filed was 7,020. The total order and judgment was 2,670. So you can see there's a huge discrepancy between what's the petitions that are filed and the actual judgments and order into treatment. So that says right there that our safeguards that we have in place in Casey's Law have been working. However, we always want to improve on our law and make it even more effective for the families in Kentucky. And sometimes that's for various reasons that the petitions may not be or may not go to a judgment and order. But just because a petition is filed does not guarantee that that person is going to be ordered into treatment. It guarantees that there will be evaluations done, that there will be due process for that individual, so that the goal, again, is to get that person the help that they need and deserve. And I don't think that this was quoted, but the CDC in an article said that Kentucky was had the fourth most overdose deaths in the nation between April of 2020 and April of 2021. So, you know, now more than ever, we need a strong Casey Law. In 2002, when Casey passed away, it was heroin for him. But since then, there's been so many other things that have come on the forefront, and fentanyl happens to be the current one. So now more than ever, we need an option for families to be able to intervene on their loved ones. Like I said, the intent of the law has been and always will be to help the families, and that includes the respondent, and to protect the rights of the respondent. And I hope that with these amendments, we can more fully realize this intention. I would close with I went to a Black Balloon event in Covington on Saturday, and there were several family members that stopped by our table that day, but two of them have stuck out in my mind so much that I just cannot stop thinking about them. One was a mom who came up to me and introduced herself, and she said, "Over there's my son and his family. He wouldn't be here today if it weren't for Casey's Law. Thank you so much." The other one, on the flip side of that, was a mom who had gotten no support from her husband, and her son, of course, was not thrilled about Casey's Law. And she was crying so hard and weeping so horribly. It broke my heart, because she said that her son had died just a few days before his 25th birthday. So for her and for me, it's too late, but we have a lot of families who will be and probably are missing their loved ones in the time that it has taken to work on this appeal. I'm sure of it. We don't want to lose any more loved ones. We don't want any more families to grieve the loss of their loved ones, because this disease does not only take the person who has it, it takes the whole family and everyone who loves and cares about that person. So I'm sorry if I've taken too much time. I appreciate the opportunity to be here, and thank you so much.
We have a motion on the bill by Representative Nemes, a second by Representative Blanton. We do have a question, Representative Decker, or comment? Okay, all right. Seeing none other, Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Brasher,
Yes.
Representative Cantrell, Representative Decker,
Yes, and just explain my vote. I really appreciate you all coming. Thank you for the changes to the bill. I think they're excellent. And I just wanted to tell you, Ms. Wethington, I know 3 people. I am the executive director of a charity that operates 2 homeless shelters for women and children. We don't have drug abuse, but many of our women come from messy backgrounds whose children, and we've had 3 who've had children with this problem, and they have used Casey's Law, and they tell me that it is, just as you described, it is a resort that otherwise they would not have to have help. I think that of the 3, 2 are still alive, 1 is not. But it is not a panacea. It's not going to solve every problem. But I want to commend you for your work and for taking this tragedy and helping others not have the same tragedy. Thank you, and I vote yes.
Representative Elliott, Representative Fisher,
Quickly explain my vote, Mr. Chairman. I proudly vote yes on this bill, as I proudly voted yes in 2004 when you presented this bill at the first time. This is an amazing bill. It's one of the best laws that we've ever passed in my tenure here in 24 years, and it has saved lives, and I'm very proud of you and proud of your devotion to this cause. Thank you, Mr. Chairman.
Representative Heverin,
Yes.
Representative Cole Carney,
Yes.
Representative Lewis,
Yes.
Representative Maddox.
Yes.
Thank you. Representative McCoy,
Yes.
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemes,
Yes.
Representative Petrie, Representative Scott,
Yes.
Representative Stevenson,
Yes.
Chairman Massey.
Yes, there being 18 yes votes, 0 no votes, and 0 pass. The same will be reported with favorable expression that the same should pass. Thank you for your testimony. I agree with Representative Fisher. If it's saving lives, it's some of the important work we do. Thank you.
If I could just say one thing, Mr. Chair, I'm very proud to carry on the work of my predecessor, former Representative Tom Kerr, who worked on this legislation in 2004, and I too am very proud of Charlotte for all of her advocacy. Thank you all.
Thank you. The next bill we're going to hear is my bill, which is House Bill 690, but I'm going to stay up here to make it quicker. Pass the gavel over to my vice chairperson, and I'm ready when you are.
Chairman, if you could introduce yourself and proceed.
I'm Ed Massey, District 66, Boone County, Kentucky. This bill is House Bill 690. It is a bill involving judicial counsel. I did not know it when I took the office of Judiciary Chair that there was a Judiciary Council, and I was on it. Apparently, it's one of those committees that was created in statute that never was more advisory and never really took any action. In working with Representative Petrie over the last 3 years, this actually started with Representative Petrie. We decided that we needed to have this council because we want our judges and the people that participate in our justice system to have input into matters that affect them. So this council, the bill basically talks about the makeup of the council. We are working with some other groups right now about the makeup and the seats on the council, but essentially the vision is that judicial matters that would be coming from the Supreme Court would be vetted through this judicial council process.
Motion on the bill.
So motion by Representative
All right,
Banta,
we have a
second by
correct. You can say it. So
Motion by Representative Banta, seconded by
Elliott, I think.
Representative Elliott, and we're going to call the vote. Oh, does anybody have any questions? We're going to call the vote.
Scott had a question.
I really am sorry, Representative Scott. I didn't see you. Go ahead.
That is okay. Chairman Massey, I'm trying to understand this bill. So it's expanding representation, but you mentioned that it already existed. So how are you going to guarantee that they actually meet?
The current makeup of the council is an advisory form. This will not be an advisory council. It would be an active council. Basically there are certain constitutional duties that the Chief Justice still has. This will not impede those constitutional duties. He still has those. It will just give the opportunity for district judges, circuit judges, other participants in the judicial process to have input before recommendations are being made that will affect them. That's it.
I think I got it. Thank you.
Representative Nemes.
Thank you, Madam Chairman, woman. This council has met a few times when Chief Justice Lambert was the Chief Justice. It also met once or maybe twice with Chief Justice Minton. I support this. The one thing that I don't like about it, though, is that it's a member of the Supreme Court that's not the Chief Justice. In the Commonwealth of Kentucky, we have a very strong Court of Justice that's run by the Chief Justice. And I think the Chief Justice should be the Speaker of the Supreme Court on this council, not one of the other members. And in this actual council, or at least he should be able to be it, I think he should certainly be it. But in this bill, he's not allowed to be on the council. And I think that unnecessarily pierces the integrity of the unification of the Court of Justice that we passed in 1976 that has served us so well. So with that change, and I hope you'll agree to put a floor amendment on that for Section 1A, I'll support it if we can get a floor amendment allowing the Chief Justice to be the Supreme Court's representative on the council.
Thank you, Representative Nemes, and I will tell you that I'd be happy to discuss that. Part of the reason is a lot of the directives that do come down come from the chief. We were just trying to create some neutrality, but I'm certainly open to that option.
Okay, seeing no further questions, call the vote.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Cantrell. Yes. Representative Decker.
Yes.
Representative Elliott. Representative Fisher.
Yes.
Representative Hebron.
Yes.
Representative Cole Carney.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Thank you. Representative McCoy.
Yes.
Representative Minter.
Yes.
Representative Mosier.
Yes.
Representative Nemes.
Briefly explain. Yes, contingent upon my vote on the floor, be contingent upon the Chief Justice. He's the Speaker of the Court of Justice pursuant to our Constitution, and he must be the one that's on this council. Contingent upon that being on the floor with a floor amendment, I'll vote yes now. Thank you.
Representative Petrie. Representative Scott.
Yes.
Representative Stevenson.
Explain my yes vote. I hate it when I agree with Representative Nemes, and I think it's important that the justice that is responsible for this program be on the council. So that's a yes.
Representative Stevenson. Yes. Representative Massey.
Yes.
Being 18 yes and 0 no's, it will be reported this will be favorable on the floor. Thank you.
All right, the next bill that we will hear is going to be House Bill 675, sponsored by Representative McCoy, and it has another bill that's been incorporated therein that was brought by Representative Minter, and I believe they're going to testify together, and they have a witness. And while they're moving forward, there is a committee sub on this bill. We have a motion on the sub. We have a second? We have a second. All in favor signify by saying aye. Aye. Those opposed? There's none. Okay. Representative McCoy, you may proceed when ready.
Thank you, Mr. Chairman. Chad McCoy, 50th District. Let me do my part real fast because I think my part is quick. The Speaker asked if I would carry this portion of a bill. He had a friend of his named Jeff Tyler, and Jeff was incapacitated and in the hospital, and because of some procedural rules, couldn't get a guardianship put in place in time. So, and ended up passing away before the proceedings stopped. So we're just making a few minor changes to allow a court, if the situation so arises, to go ahead and temporarily put somebody in the position of conservator or guardian until we can get the rest of the hearing to go. And then secondly, allowing someone who's not the person incapacitated or the county attorney, to come in and be the petitioner. So very minor change to address that problem, and we would like to have this law named after him. So that is the sum and substance of my bill. Happy to answer any questions on it.
Representative Elliott, would you mind if we go ahead and have the bill presented, and then we'll come back to you? Okay.
Yeah, thanks. Representative Patty Minter, representing the 20th District in Bowling Green, and I'm honored to work with Representative McCoy and Speaker Osborne on these very necessary updates to our conservatorship law. 118 that is now rolled into 675 was the CARE Act, the Conservatorship Advocacy to Remove Exploitation Act. And this bill is supported and has rolled into 675. This is supported by the Mental Health Coalition as a priority bill. District judges, thank you, district judges, are supportive. Spoke with John McGarvey. Uniform Law Commission says it's a good bill and does not conflict with any of their uniform acts. This bill does 5 things. It is designed to provide greater protections and clarifications for individuals with disabilities for whom a guardian or conservator has been appointed. The bill requires that more information be gathered and available regarding near and extended family members who play a role with the individual. It assures that the individual is apprised of any pending civil or criminal actions that are filed against him or her, and requires notification by the conservator or guardian that these notifications are made. It affirms the individual's right to contact and retain legal counsel, and it importantly gives the individual the right to modify or terminate their current guardian or conservator arrangement, and provides for court-appointed counsel if needed in such cases. And it continues the long-standing requirement for a jury trial for the termination of a disability unless ruled unnecessary for very specific reasons. House Bill 675 is successful in walking the narrow line between expanding protection of and broadening self-determination by the individual with a disability. And I would now like to introduce the person who brought this issue to my attention. As many of us know, our best work sometimes comes from our constituents who contact us with an issue that was not on their radar, and that's certainly true in my case. So I would like to introduce to you the person who brought conservatorships onto my radar. This is Ashley Shepard Porter, who practices in Bowling Green in family law and adult guardianship law, and she has a few brief remarks.
I'm usually loud enough anyway. I apologize for that. I've been a practicing attorney now for 13 years, and those of you who are also members of the bar may recognize that whenever you were a young attorney yourself, you were told to go down to the circuit clerk's office and put your name on a list. And those lists are to become court-appointed counsel for respondents in guardianship and conservatorship cases. And I'm no longer a young lawyer in any room. I'm now a seasoned one. And I've got enough war stories under my belt now to tell you that what I have seen in the, conservatively speaking, 300 or so cases that I've done in guardianship, that we need systemic change with regard to our guardianship and conservatorship laws. I've witnessed that behind the closed doors of these quasi-confidential proceedings, but then the world got to see the need for those changes in Britney Spears' case. Everybody is familiar with that. So House Bill 675 would modify the existing language of 7 statutes in Chapter 387 as it relates to the adult guardianship statutes. And while the modifications may appear minimal in writing, they have far-reaching effect. This bill would ensure that the right people are at the table when we're discussing disabled adults. It closes the ability for disgruntled parents to bring a guardianship action for their 17 or 18-year-old while surreptitiously trying to keep the other co-parent out by failing to tell the court that there are family court orders in place. Conversely, it ensures that if your grandfather who has Alzheimer's accidentally wrote some cold checks, that the right authorities are notified of the circumstances so a sheriff's deputy doesn't show up at his door with a warrant for his arrest. It impresses upon the court its own duty to let someone know when their rights have been stripped from them that they don't just have the option, but they have the right to come back before the court and ask for a change in their circumstances. And if your rights have been stripped away from you by the court, think about the glimmer of hope that that gives you when a judge themselves tells you, you have the right to come back before me. It makes it easier for people to be able to modify their guardianships, to terminate their guardianships. Because right now, someone has to know who they've got to call, what lawyer that they call in order to be able to get that done. So this impresses upon the Bar Association itself, even if they do not practice in this type of law, to let the circuit clerk know and get the ward in contact with the circuit clerk in the event that they receive one of these calls. Because somebody might not know who practices in that type of law, but they might know how to call 800, 800, 4600. So this would tell everyone who they need to get in touch with. It also expands the ability of the ward once they get back in front of the court, not to just be heard in front of the judge, but to be heard in front of a jury if they so choose. It also expands the district court's ability to give certain relief to wards and their family members. Right now, as the law stands, the district court's hands are tied. This specifically gives the district court the ability to seek visitation schedules for a ward and a loved one. Right now, if you're...
We have a motion on the bill by Representative Heverin and a second by Representative Nemes. Typically, when you're doing well, we stop talking. But with that, I'm going to defer to Representative Elliott, who had a question earlier.
Thank you, Mr. Chairman, and thank you for presenting this bill. I had a bill several years ago that rewrote the guardianship conservatorship laws to some extent with the removal of the jury trial as a requirement, which we were the only state at that time that had that requirement up until that bill passed. There is a mechanism for, I practice in this area, so there is a mechanism to have a temporary or emergency guardian custodian appointed now in the law. Typically, though, that requires a hearing once the petition is filed. So I guess my question is, why isn't that sufficient to cover the scenario that you just talked about? Because
that requires action by the county attorney. And in some of our counties, I won't name Jefferson, they have a different process and do it differently. Mm-hmm. And therefore, we've had this scenario pop up where if they choose not to act, and Representative Elliott, I think it's like ends up taking like 4 days or something like that. And it's in that intervening time that this emergency limited conservator or limited guardian pops up. So we just needed to expressly give this authority to the court and to someone else to step into the role of petitioner to get the ball rolling.
I see. If I might follow up, Mr. Chairman.
Certainly.
In the district that I'm in, it's fairly routine for a family member to go to a private attorney who then files the petition. Of course, the county attorney is consulted in part of that process. But I guess, I think there's still need for some type of a hearing before someone is placed under even an emergency guardianship, because they're going to have to be appointed an attorney if they can't afford one. Obviously, a guardian ad litem or court-appointed counsel.
And if you look
is that circumventing that process?
No, not at all. If you look at paragraph 1, there still has to be a finding by the court of a danger of serious impairment to health or safety of the respondent or damage or dispossession to the property. So we're still talking about getting the judge involved. Now that's going to be something less than the full-on hearing where all of the evidence is presented. This is simply allowing for this to happen immediately. Almost like a TRO situation, where I can come in a civil case, go ex parte, tell the judge, we've got to do this now, but we'll be back in front of you tomorrow with everybody.
Okay. Thank you, Mr. Chairman.
Seeing no further questions, Madam Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher. Representative Cantrell.
Yes.
Representative Decker.
Yes.
Representative Elliott.
Explain my vote, Mr. Chairman. I'm not totally convinced that this is needed, so I will pass at this time.
Representative Fisher.
Yes.
Representative Hebron.
Yes.
Representative Colcarney.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Thank you. Representative McCoy.
Yes.
Representative Minter.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
I'm going to follow Representative Elliott's lead on this and pass.
Representative Petrie. Representative Scott.
Yes.
Representative Stevenson.
Yes.
Chairman Massey.
Yes. There being 15 yes votes, 0 no votes, and 2 pass, the same will be reported with favorable expression that the same should pass. As amended by the committee substitute. And thank you for your presentation, and have a wonderful day.
Thank you.
This brings us to our final bill for today, which is going to have some discussion. So it's going to be House Bill 489, sponsored by Representative Blanton. And I know there are several people that are going to testify on this. We did gain a little bit of time, but that doesn't give you the ability to go on and on. We got to keep this. We need to wrap up by 1:45 in order to get members over to the floor for session. So we do have at least, I think, 2 witnesses in addition to the sponsors speaking favorably and maybe 2 speaking in opposition. And we'll try to get all of that testimony in here before we call a vote on this bill. With that, Representative Blanton, you can introduce your guest, and if you're ready to proceed, please do so.
Thank you, Mr. Chairman, members of the committee. My name is John Blanton. I'm a representative of the 92nd District, and I will allow my guests to introduce themselves.
Patrick Flannery, 96th District.
Eric Schuler, the Alliance for Responsible Consumer Legal Fund.
Mr. Chairman, today I've come before you all to present House Bill 489. The intent of House Bill 489 is to put in place guardrails to protect consumers who are awaiting a settlement and a financial need were to arise, whether it is to pay an electric bill, a mortgage payment, a car payment, or in the case of my colleague, Representative Flannery's client, simply to buy some Christmas presents for his family. This product is currently being used in Kentucky without any parameters in place to protect the consumer or the funders who provides the product. Simply put, this legislation brings forward proper legislation that regulates this industry that is currently not regulated in the Commonwealth of Kentucky. And with that, Mr. Chairman, I want to yield to my colleague for further testimony to show the need for this product and this legislation in Kentucky. Representative Flannery.
Thank you. Thank you all. So as many of you all may know, I am an attorney by trade, and I have a small town practice, and at any given time I probably have 5 to 10 car wreck cases that I'm working on, and these types of products have always been something that I have tried to lure my clients away from for different reasons. But one of the reasons I've co-sponsored this is I really do believe that sometimes these loans can be very beneficial to people that we represent. I had a client that was very seriously injured in a car wreck case, and he was unable to get any sort of unemployment for different reasons, and was not able to get disability payments, and he had really fell on hard times financially. And he came to me and talked to me about this, and I discouraged it at first, but after talking with him, I set him up with a company, and he received a $1,000 loan, and primarily what he needed was $1,000 just to get him through Christmas time. He had a hard time paying bills and other things, and I hear a lot of rhetoric that this is going to cause more litigation, and I think we really need to disabuse people of that notion. This is not going to cause more or less litigation out there. We're going to have the same amount of lawsuits that will be filed. Secondly, the companies that lend these dollars, this is a non-recourse loan. So they're going to be smart about who they lend this money to. They're not going to lend money to people that have a case that is unstable, questionable, or without merit. These loans are typically, smaller amounts. The client that I referred to recently had very sizable damages. There were fairly large insurance policies, and he received a $1,000 loan. So these are not large amounts of money. No way would it should not encourage anybody to file a lawsuit to get these loans, because the lenders are not going to lend money to people that do not have good cases. And I think that's a very important fact to realize. But I've seen some comments that indicates that, these loans are illegal in certain cases. And I don't really want to bore people with the doctrine of champerty. Some of you lawyers may have heard that. I know, honestly, I could not remember that concept from law school. I see Representative Elliott shaking his head. Maybe he doesn't either. But it's just a very archaic concept. And, there are a lot of gray areas with these products. It's kind of murky. And I think that's one of the good things about this bill is it does set some guardrails. It helps regulate it, as Representative Blanton said, and sets forth some safeguards to be sure that that our constituents, the people that we represent, if they use these products, that there is some law guiding this, and it's not the wild, wild west. And like I said, it's important to note that these are non-recourse loans. So obviously that is going to, it's very risky. It is going to be a higher percentage payment, but I mean, that's just kind of part of this transaction. But, in no way, shape, or form are people, forced to do this. I actually think it's probably not right for, most of my clients, and will discourage it. But for some people, it can be a big help. So appreciate the opportunity to discuss, and proud to co-sponsor this bill.
Thank you, Representative Flannery. And I'll point out that $1,000, all he wanted to do was buy his kids some Christmas presents. Okay, he wanted to make sure his kids, even in that time period, was able to have some type of Christmas. And with that, I'll defer to Eric.
Thank you. Chairman Massey and members of the committee, my name is Eric Schuler. I'm the president for the Alliance for Responsible Consumer Legal Funding. We are a national trade association that for companies that provide the consumer legal funding across the country. Briefly, let me just kind of reiterate what consumer legal funding is we provide financial assistance to consumers who have a pending legal claim that is to be used for immediate household needs. It's not to be used to further litigation. It's only to make sure they have a roof over the head, food on the table, and they can pay their bills. What this legislation does is set up proper regulations and set up a structure with strong consumer protections, along with the abilities to offer the product properly. Some of the highlights of the bill is it clearly defines what the product is. It requires the companies must register with the Commonwealth prior to doing business. If they don't, they're subject to a $50,000 fine. They must have a registered agent in the Commonwealth. They must put up a bond. Clear notice and disclosure to the consumer. The consumer has 5 business days right to cancel the contract with no penalty. And the company also states that the company shall not have a financial say or a say in the settlement process or the legal claim itself. The consumer's attorney must acknowledge the contract, and there is no quid pro quo between the funding companies and attorneys. And also it states the attorneys cannot have a financial interest in a funding company as well.
I make a motion on the bill, Mr. Chairman.
We have a motion on the bill by Representative Elliott. Is there a second? We have a second by Representative Nemes. I know that we do have some other folks that are speak for and against. So with that, and because we've allotted the time, we're going to allow that to proceed. Typically we would stop and potentially vote on the matter, but I know that I will honor those witnesses that have signed up to testify. And we also we'll have some questions. Do you want to hold your question till the end? Okay.
Happy to answer any questions.
Okay. With that, I believe that we do. Was there anyone else, Representative Blanton, that was going to testify on your behalf? Was that? Is that it? Okay. So we have with us virtually today Jack Kelly, and I don't know if he had a backup.
Yeah, Mr. Chairman, I have a backup. I'm at a medical appointment that I apologize. My colleague, Mr. Hosker, will briefly testify, and we'll keep our remarks brief and appreciate the members of the committee and happy to answer any questions about the one singular amendment that we'll seek at a time, just a technical amendment.
All right.
I yield to Mr. Harrison Hosker.
Very good. Sir, please identify yourself, name, address, and who you're affiliated with, and then we will give you the floor.
Okay, my name is Harrison Hosker, and I'm with the American Legal Finance Association.
You may proceed, sir.
Thank you. Chairman and members of the House Standing Committee on the Judiciary, thank you for allowing me to address the committee. I am Harrison Hosker of the American Legal Finance Association, also known as ALPHA. I'm here today in support of House Bill 489 with one technical amendment that we asked to be adopted. By way of introduction, ALPHA is a trade association consisting of 32 of the nation's leading and largest consumer legal funding companies that do business throughout the United States. Established 17 years ago, one of ALPHA's first actions was setting industry standards for the consumer legal funding industry. The cornerstone of these best practices is transactional transparency and transparent disclosure to consumers. As a result, all ALPHA members ascribe to ALPHA best practices. It is critical for the committee to know that ALPHA members do not provide funds to individuals for any costs, fees, or expenses related to the prosecution of litigation. Therefore, the plaintiff can solely use the funds provided by ALPHA member companies for their personal life needs like rent, food, or other expenses. ALPHA best practices include prohibiting any funds being used for the cost of litigation or attorney fees, prohibiting the funding company from being involved in any decisions relating to litigation, prohibiting funding companies from paying any referral fees, prohibiting funding companies from false or misleading advertising, and requiring attorney acknowledgement of all fundings. This legislation before you today establishes a robust system of registration, licensure, prohibited practices, and requirements for transparency and uniformity in contracts, while ensuring consumer protection for those who need consumer litigation financing. Kentuckians truly deserve law that will provide consumer protection. ALPHA commends you for considering this legislation and welcomes working with you to address any concerns. ALPHA has led the charge in helping adopt sound consumer protections law in numerous states, including Indiana, Oklahoma, Utah, Nevada, Tennessee, Vermont, Ohio, Maine, and Nebraska, and looks forward to the Commonwealth adopting this needed law. Consumer legal funding provides consumers with a lifeline when they have nowhere else to turn. It enables a plaintiff to obtain the settlement they deserve and not to be forced to accept an unfair offer. If you have any questions or concerns about this industry, the ALPHA members and I stand ready to work with you to address these concerns. And I again would like to thank the committee.
Thank you, sir. I appreciate your testimony. We next have, I believe, Carrie Silverman that is speaking in opposition, I believe.
Thank you, Mr. Chairman. Can you hear me okay?
Yes, sir. You may identify yourself, where you're located, and who you represent or who you're speaking on behalf of.
Sure. Mr. Chairman and members of the committee, thank you for the opportunity to testify. My name is Carrie Silverman. I'm here on behalf of the American Tort Reform Association, which is a national group that seeks predictability and fairness in civil justice in Washington, D.C. and across the country. While this bill may be, I'm here to express our concerns with House Bill 489. While this bill may be intended to protect consumers, if enacted, it will legalize lawsuit loans that courts have already found are now prohibited in Kentucky, and it'll allow lenders to charge excessive interest rates in exchange for what we view as a licensing requirement and very relatively weak regulation. Over the years, ATRA's watched the lawsuit lending industry emerge and grow with concern. A quick search on the web turns up numerous companies that are advertising, quote unquote, lawsuits for cash. These businesses often offer people who've experienced an injury quick cash in exchange for being entitled to a portion of their settlement. The companies that promote these arrangements often claim they're not subject to lending laws that ordinarily protect consumers because they offer what others have already called non-recourse loans, meaning they only get paid out of the settlement or the judgment, like a contingency fee lawyer. But in actuality, these arrangements, they could take advantage of consumers with extraordinarily high payday loan type rates that can eat up their entire settlement. And there's little true risk involved in these cases. Lenders know it's almost certain that the consumer will receive a settlement from the defendant or its insurer, whether it's a ordinary slip and fall or a fender bender or other action. It's just a matter of time, and that time is during which the lender can profit from the extremely high interest rate. It would be foolish for them to make the loan otherwise. And from a civil justice perspective, these types of arrangements are also problematic. They complicate the ability of parties to resolve litigation, and they drive up settlement demands. Why? Because a person's taken out a lawsuit loan must not only calculate how much of his settlement's going to go for the lawyer's attorney's fees and costs, which might be 35 or 40% or more, but how much of what little then remains will go to repay the lawsuit loan. And once the plaintiff takes out a lawsuit loan, he can't just walk away from the litigation, even if it turns out that the lawsuit shouldn't have been brought in the first place. Abandoning the lawsuit could subject them to immediate repayment of the entire loan and with interest and fees. And these arrangements, they can also encourage litigation, as some people who may not have sued might be enticed by the prospect of getting some fast money. And keep in mind that lawsuit lending isn't needed to promote access to justice. We already have contingency fees for that reason. I'd like to give you an example of how this system works in a case it actually involves a Kentucky resident. Christopher Bowling was seriously injured when a gas can ignited, and he sued the manufacturer of the can, claiming it was defective. During the litigation, he took out 4 lawsuit loans totaling $30,000. The loans accrued interest at a rate of 4.99% per month, which may sound like not a lot, but when it's compounded monthly, he was subject to an effective annual rate of 79%. So when the lawsuit settled 5 years later, the outstanding balance on his $30,000 loan was $340,000, more than 11 times the amount that he had borrowed, and likely a substantial, if not the entire settlement he would have received as compensation for severe burns. Unsurprisingly, Mr. Bowling said, "I'm not going to pay that," and he sued the lawsuit lender. And a federal district court and a unanimous federal court of appeals found the lawsuit loan agreement was unenforceable under Kentucky law. And its reasoning was that lawsuit lending violates the state's existing prohibition on what's known as champerty, which doesn't allow third parties to have a financial interest in litigation aside from the parties and their lawyers. And the reason for that prohibition, the court noted, was because it reflects Kentucky's strong public policy against assignments that compel a party to prosecute a claim he no longer wishes to prosecute. It complicates the ability to settle cases, and it encourages litigation. And the court said that the loan agreements also violated the state's law against excessive interest rates, which generally doesn't allow an APR above 8%. And the court invalidated the agreement and it required the consumer to repay the lender only the principal and the lender's cost, which was $34,625 as opposed to $340,000. That's consumer protection, and that's what Kentucky law is now. So what HB 489 does, in effect, is it carves out lawsuit loans from Kentucky's champerty statute. It carves out lawsuit loans from Kentucky's usury statute, and it replaces these strong protections that are already in place with a licensing requirement that legitimizes these types of practices, and it will allow the lawsuit loans to flourish here. Thank you for the opportunity. I welcome any questions.
Thank you. We do have another person speaking, I believe, in opposition. Nick DeAndre, if you want to get seated, identify yourself, and then you may proceed.
Thank you, Mr. Chairman, and thank you, members of the committee. I'm not a legal expert. I appreciate you allowing me to be here. And I'm Nick DeAndre with UPS. I'm the Vice President of Public Affairs. And in true UPS fashion, I promised the committee chair that I would do this in 2.5 minutes, and I promised an on-time delivery. So
is your light on? Make sure
it is.
Good.
Maybe I'll pull it a little closer. How's
All right,
that?
Thank you.
But I am here. I just want to say I am representing various businesses from the Kentucky Chamber of Commerce, NFIB, Kentucky Association of Manufacturers, Kentucky Hospital Association, Kentucky Association of Healthcare Facilities, Kentucky Home Care Association, Greater Louisville, Inc., Kentucky Trucking Association, Kentucky Farm Bureau, Kentucky Medical Association, Kentucky Civil Justice Alliance, and the Insurance Institute of Kentucky. I just wanted to give just from a business perspective, what this means for us in states that do have these third-party litigation financing legalities where it is legal. We do see higher litigation costs. We're also extremely concerned about what it would mean for insurance premiums. Our insurance premiums at UPS have gone up 440% in the last 2 years. So that's why I'm here at the table discussing that this bill could adversely affect both of those, not just for us, but other companies in the Commonwealth. And just know that for every dollar that we're not paying or that we're paying for litigation or paying for insurance premiums is a dollar that can't be invested in our people, our plants, and our equipment here in Kentucky. So, Mr. Chairman, thank you.
Thank you. We do have some questions, and will the people asking the questions or representatives asking the questions please direct your questions to whom they go to, as we have testimony that was given by video. We just need to know who's going to be answering the questions you may have. With that, Representative Nemes.
Thank you, Mr. Chairman. It's interesting that the case that the gentleman brought up was a case that I represented the defendant on. I was not involved in the loan. I represented the gas company that was sued by Mr. Bowling, who my memory was Mr. Bowling was an attorney. Whether that's here nor there, he probably knew more than most people the contract he was getting involved in. My question is this: there's no cap. I think the situation that we heard kind of shocks the conscience, doesn't it? You loan somebody $30,000 and they receive $300,000. So generally, I'm fine with these contracts. It's a decision that somebody makes, but the bill doesn't have a cap in it. Can we put a cap on it?
Very good question, Representative Nemes. Understand your concern. Originally, that was tossed around. There was some caps in there. We're certainly willing to take a look at that, put reasonable caps in place that protects the consumer and the companies here as well, and would be welcome to take a look at that for a floor amendment. Let me point out something here that we've been hearing, and that is this. First of all, this is going on in Kentucky right now, but it's illegal, but it's still going on. So that's why we're trying to put some guardrails in place to protect our consumers when they need it the most. And the big fear from a lot of people is they don't want them to have this protection because it means they can stay in the fight longer. They want to settle quickly so they can settle cheaper. They don't want them staying in this fight longer. This allows them to pay a mortgage, pay an electric bill, keep them in the fight longer because they have been injured or damaged in some way and deserve the right to be able to get the return on what has happened to them. I'll defer to Eric.
No, thank you, sir. And one of the things I just want to also to clarify that was stated previously is that the consumer only has to meet this obligation if they have a settlement and if there's enough money out of the proceeds of the settlement. It was stated before that if the consumer drops the claim that they're still on the hook. They're not. And that's why we have it specifically stated in the statute that only out of the proceeds of the legal claim can this obligation be met.
Eric, what can we do to make sure that somebody that gets a $30,000 loan doesn't have to pay back $300,000? And so I don't know if that's put a cap on the total amount. Maybe it's double the amount of the loan. Put a cap on percentages. But I don't know that works very well, especially with civil trials not getting trials quickly anymore. You can't get one in 2 years, even if you're hustling. So I don't think anybody wants a Kentuckian to have to pay. That doesn't make sense. It shocks the conscience. Wouldn't you agree? It shocks the conscience that somebody's paying.
And I agree, and that's part of the reason why that situation happened in the case with Prospect. Is there's an old the saying is pigs get fat, hogs get slaughtered. They were a hog in this situation. One of the things we do have in there is a time cap that all fees stop at 36 months. But I think what's important in this situation here, too, is you have an attorney looking over these contracts. They're going to be involved in the settlement process. So if the attorney goes, listen, you guys are charging outrageous rates here. On the front end and on the back end, they're negotiating these contracts. Also, all the way through the process. So let's say we look at a claim, say we think it's going to be valued $50,000. Also, as the case progresses, find out there's some shared liability with it, it's not going to settle. That attorney is going to get a hold of that funding company and says, listen, don't expect a big return on this thing because this is going to happen. All of a sudden, the case settles for $20,000. We already thought it was going to settle for $50,000. That company is going to probably barely get their principal back. That attorney has a fiduciary responsibility with their client to negotiate it. That's why we make sure the attorney is fully involved in this process all the way along because it's their responsibility to look out to make sure their client gets the best settlement that they can.
Thank you, Mr. Chairman.
Representative McCoy.
Thank you, Mr. Chairman. I'll have some questions for Nick. If you want to come back up to the table, you can sit by Representative Blanton there. First of all, I want to clarify something. This is not illegal. Champerty is illegal, but this is not illegal. And I say that because it's been going on openly, notoriously, and continuously my entire career. Since 2004, I've done almost exclusively plaintiffs' personal injury work. And Nick, I would love to see the evidence that the costs are higher in states where this is regulated. Not doubting it, just have never heard that before. Would love for you to share that. But let me ask you this question. Because I've got a job to do, and that is to do whatever's in the best interest of my client. First and foremost, that's my ethical obligation. So I've got this case right this second. This was last week's decision. I won't mention Dan's last name, but my client Dan was rear-ended sitting in a stoplight. I think everybody would agree he's not at fault. The lady that hit him has no insurance. Dan has a really nice policy that he pays for himself every month and has never missed a premium with one of the companies you mentioned you're here on behalf of. He has a large uninsured motorist policy, which means if he gets hit by somebody that doesn't have insurance, his company is going to step up and pay his medical bills, his lost wages, and some amount for pain and suffering. He has now been told he has to go have surgery. He is going to be out for 2 months. Who's going to pay his mortgage? Who's going to pay his car payment? Who's going to pay anything in that man's life? Because I'll tell you who's not paying is the big insurance company that without a doubt owes him the money. It's not even a question. There's no question as a liability. There's no question if they're going to pay. It's a question of when are they going to pay? And because they won't pay along the way, I'm open to suggestions. What does Dan do?
Yeah, and I think I'm on here. Maybe Carrie can help answer that too. But I can tell you, I can't speak for the insurance companies. I can just say, in our cases, what ends up happening, right, is the fact that because of the usury rates or higher than usury rates that are being charged, Dan, in your case, if you were to settle, right, or UPS offers a settlement agreement, he owes more than the settlement's worth, so he has to take it to trial because if he loses, he doesn't have to pay anything back.
That is a rare occurrence, and I haven't really seen it happen with good companies and good lawyers involved. I hear that. I can see where it would cause problems getting them resolved if somebody owes more than the settlement. But come back and answer my question. What are the options for somebody who is completely without income, completely not at fault, has a massive insurance policy, and we're just being delayed? I just don't know what else to do. I don't recommend my clients to do this. I don't like them to do it, but I'm stuck.
Understood, but would you also agree that maybe the interest rate should be a limit once where they're not ended up having to pay back, thousands and thousands of dollars more than what they could get a loan for maybe somewhere else, or in a way in which it's fair to the plaintiff?
So I would say that I'm a big free market guy. And if there is a loan that is available at a cheaper rate elsewhere, I would run my clients there at a heartbeat. I can tell you, traditional lending operations do not lend based on a contingency fee lawsuit because it is in fact contingent. There's no guarantee that we're going to get anything. So I don't know that it exists. Absolutely, if we had other options, the market would drive those rates down. And I think that's sort of the point of this bill, is if we make it clear that nobody's going to get sued, then now hopefully people are going to come into this market space and we'll get some of those options. But I apologize to my friend Nemus. No, I'm not for caps. We don't tell the banks what to charge. I mean, I guess at some level we do. There's a usury rate. But at the same time, it's one of those, the market will figure this out. So anyhow, thanks, Nick. I do want to see that evidence there.
And I will try to get you the data from the other
Thank
states
you.
For sure.
Appreciate it.
Mm-hmm.
Representative Scott.
Thank you, Chairman. Representative Blanton, I just want to make sure I understand this bill. So these companies already exist. There's no accountability right now with those companies. This bill is saying we want to have some accountability. Is that correct?
That is correct.
Okay, thank you. Thank you, Chairman.
Representative Kulkarni.
Thank you, Mr. Chair. Representative Blanton, I had a quick question. I just want to make sure I understand. So on page 6, the clause where it says in bold typeface that if there's no recovery, that the individual will not have to pay anything back in excess of their recovery. Is that exclusive of the interest that's going to be charged?
Everything, right? That would exclude everything. If they don't recover, they don't pay back
Anything
anything
at all? Okay.
At all.
So what then is the incentive for companies to get into this lending space?
Well, I'll let Eric, but I'm going to take a stab at. They're going to look at these on a case by case basis and think that if you've got a good case and you need the monies, and it's like a credit card. What's their rent? It's what they make back in their interest, right? But I'll let Eric answer that.
Thank you. It's a free market solution. There's a need for this product, so these companies have come up and developed this product to fill that need and to fill that gap. As Representative McCoy said, what are people going to have to be able to do when they're out of income or to make ends meet? And to address Representative McCoy's issue about the free market, I can point to Oklahoma. Oklahoma doesn't have any rate caps in it. Oklahoma has probably one of the lowest rates that are charged across the country because companies know exactly what everybody else is charging. And it's an extremely competitive market down there. There have been 3 companies that have been started in Oklahoma since the legislation has passed, and they're driving the national players, making them chase their tails. Because the fact that they're a local provider, they can say, hey, I'm right here in Oklahoma City, or I'm right here in Tulsa. You need something to deal with? Let's go talk about it. You don't need to talk about that guy in New York or LA or wherever that is. That's what the market does. Once you level the playing field, meaning that you notice and disclose all the consumer contracts together, so attorneys can go from company A, company B, company C, and see exactly what the terms and conditions are, it does drive the rates down because it is a very competitive market.
Thank you.
Representative Mosier.
Thank you, Mr. Chair. I think you may have just answered my question. I wanted to know about other states and the competitive markets. It does shock the conscience to think of someone paying the interest rates that were described. I'm not sure that I'm in favor of caps, but that would certainly solve the issues, I think. In some cases. I mean, I think maybe I just contradicted myself because I'm talking about competitive markets. It's a very kind of confusing issue. I think, I understand both sides of this. I'm just trying to understand exactly what this is. I guess the long-term effects of this, as well as the immediate provisions. I don't know. I'm not sure where I stand on this right now. So I appreciate your comments about other states. I think that was really my primary question. So thank you.
Representative Fisher.
Thank you, Mr. Chairman. I have not read the Bowling decision, but that seems to be the primary issue here. Under that decision, if someone enters into one of these contracts, these financing contracts, receives a settlement, and then decides to rescind that contract without paying the financing company, then he does not have to pay the financing company because it's unenforceable under the Bowling decision. Is that my understanding? I haven't read the case.
To some extent, yes, but it also creates a lot of ambiguity. One of the parts of the Bowling decision was because the judge in the case said, because there's nothing on the books, I'm paraphrasing this, nothing on the books regarding this financial product, I'm going to say that it was usurious and championous. If this statute were in place, that decision never would have happened. And then to may address Representative Mosier's comment before, and also yours with this case, this started over 10 years ago. I can tell you the industry has matured and changed dramatically in the last 10 years. You're not seeing those types of rates, and you're not seeing those types of charges being done anymore because this has become a very competitive industry. And attorneys will see 3, 4, 5 of these contracts a year. And if they have a bad player, I can tell you right now, they're never going to work with that company again, and they're never going to operate again in that state.
So, follow up.
Please.
So does anything in this bill state that these types of contracts are legal?
Representative Fisher, it's Jack Kelly. Good to see you again, sir. I apologize. The issues that were brought up by Mr. Schuler was that the case was brought under diversity in Erie in the bowling case. There was no statutory doctrine in Kentucky on whether this was a loan or it was championous. The court took the position that they could sit in the chair of Kentucky and interpret what they felt Kentucky's law would be. What this statute does is that resolves that ambiguity or lack of statutory clarity for any court that were to look at this, and therefore remove that uncertainty.
Thank you, Mr. Chairman.
Representative Fisher.
Thank you. Representative Bratcher.
Just quick, too, just to be clear, the interest is really just paying upon the future settlement, right? That's what the interest is, concerns. And then second question, then a quick comment. Are these funds, are they delivered like in a lump sum or a draw over time? Somebody said 2 years for settlement.
It depends upon how the person wants it structured. In most cases, they're delivered to the consumer in a lump sum. So it's wired to their bank or a check is sent to them or whatever it is.
But it's all internal. It's just between the two parties.
Yeah, it's
right?
between the two parties, however they want it.
Yeah, and just quickly, I know everybody on this committee, especially the lawyers, roll their eyes when I complain about how long it takes for these judges and courts to move along. I mean, 2 years, 3 years, it's crazy. And during this off year, I'm just going to find ways that the Constitution could be changed to have a speedy trial and verdict. So that's all. Thank you.
Thank you. We did have one person that also signed up. I didn't want to neglect anyone. I can only give Mr. Ed O'Neill O'Daniel a couple of minutes. If you'd be very limited, sir, because we're going to have to vote and get to session. But do you have anything you'd like to add?
Thank you, Mr. Chairman. I'm Ed O'Daniel. I'm here on behalf of the Kentucky Trucking Association, which is one of the 17 groups that signed on in opposition of this legislation. KTA, the Kentucky Transportation Association, supports the long-standing public policy that money damages for injury sustained in accidents is a highly personal right, and that the practice of assigning the proceeds of a lawsuit to a stranger violates public policy. Bills have been filed in the General Assembly almost every year in recent years trying to change the Constitution to allow the General Assembly to limit damages. That's a debatable matter. Pass this bill and it might not be debatable anymore. This legislation will have the effect of driving up the cost of settlement of cases and will result in higher awards being paid in these cases. The Kentucky Trucking Association asks that the committee not vote to enact this piece of legislation.
Thank you, sir. Final word, Sponsor Blanton. Representative Blanton.
Thank you, Mr. Chairman and members of the committee. I think you all have seen here, this is about putting guardrails in place on a consumer protection. And when it comes down to it in the end, it's no different for someone if they choose to take a loan with a company or a group. That's our personal choice. We know what we're paying, whether the interest rates, whatever it is, and more times than not, these are people in need. I see it in my area of the state a whole lot. They're in that situation. Nobody else will lend them money. They just need enough to get by. And they do have some legal protections with their attorney. Their attorney's not going to let them be signing up with somebody who's going to take advantage of them. They're going to be pointing them in the right directions to people that can help them so they can get through this. And yeah, it might mean higher settlements because they're able to stay in the fight longer to fight what they deserve to get from the beginning. And so this is a good consumer protection bill. It puts guardrails in place, and I hope each of you can vote yes on this House Bill 489 today. Thank you, Mr. Chairman.
Thank you, Representative Blanton. We have a motion and a second. Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Cantrell.
May I explain my vote, please?
Please.
Thank you. I'm going to pass today. I have a lot of mixed feelings about this practice. I'm familiar with the Bowen case pretty well, and I'm a big proponent of injured people having the resources that they need to proceed with their legitimate claims. But the problem is when these loans that are intended to provide a short-term bridge to get them through the litigation end up costing them so much more in the long run that it affects their settlement, which is a legitimate resolution of maybe even a lifetime's worth of injuries. And you have a short-term bridge loan cutting into that cost, and it becomes a long-term problem for the system. And just because I have such mixed feelings about this today, I'm going to pass, but I do hope the discussion moves forward. Thank you.
Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Pass.
Representative Heverin.
Pass and explain my vote. Okay. Okay, thank you. I just like to be respectful. I'm going to pass today. I understand where you're coming from on both sides of it, and I would like just to see the final version. I know that one member of the caucus wants to see caps and one doesn't, so I just want to see the final version of the bill. And Representative Blanton, I'll be working with you to hear more on that. Thank you.
Representative Kulkarni.
Briefly explain.
Please.
I'm going to pass today. I understand the intent, but I think there were a lot of questions raised, so I'd like to resolve some of those in my mind before I decide. Thank you.
Representative Lewis.
Explain my vote.
Please.
Thank you, Mr. Chairman. Had several questions. I look forward to working with my seatmate and getting to the bottom of that, but for that to now, I'm going to be a yes. Thank you.
Representative Maddox.
Yes.
Representative McCoy.
Yes.
Representative Minter.
Today it's a pass. I share the concerns my colleagues have brought up, and I, like you, I want to make sure people have roofs over their heads and food in their bellies. So I want to get to that. So I look forward to working with you to resolve all these issues, but pass for today.
Representative Mosier.
Explain my vote. I'm going to be a pass today. I have some concerns, and I'd like to work out some of the concerns of the folks who are in opposition. I'm worried about a few things. I think it might drive up premiums. I'm willing to work on this, and look forward to getting to a yes on the House floor.
Representative Nemeth.
Quick explanation, please.
Yes.
I'm going to vote yes. I promise that to you. And I think this is a good bill. It has the makings of a really good bill. We need guardrails in place. But Representative Blanton, we have to have caps. Not only because these people are poor people who are getting these loans. It's not me and you. They're poor people. And they can't afford this kind of an interest. We have usurious caps or caps against usury loaning on payday lending. We must have caps. And also, this wasn't brought up today, but this also implicates the taxpayer. Because if, as one of my friends mentioned, I think Cantrell, if this is a lifetime of injuries and the monies that they've received is depleted going to one of these companies, and I don't have any problems with these companies if they follow the rules, but if a lot of that money goes to the companies, then that individual is going to have to be taken care of by the taxpayer. And so this has very massive implications. We have to have caps, or I won't be able to support it on the floor. But I'm a yes today. Thank you, Mr. Chairman.
Representative Petrie. Representative Scott.
Yes.
Representative Stevenson. Chairman Massey.
Yes. There being 11 yes votes 6 pass votes and 0 no votes, the same will be reported with favorable expression that the same should pass. I would ask you to continue working on this because I don't know where it'll be on the floor, but for purposes of today, it does pass out of committee. So thank you, gentlemen. Seeing no other matters except for this announcement, we will have a meeting tomorrow upon adjournment to discuss 3 bills. I tried to get a text out to folks, but if you didn't get it or if you have questions, please ask me. With